Ladies and gentlemen, thank you for coming. Is the sound all right? Can everybody hear? Great. So thank you for coming today. Before we start, we'd just like to tell everyone, if anyone is tweeting today, all you technically inclined people, you can't hear us. Okay, sorry. So if anybody is tweeting today, if you'd like to use the hashtag #ACEgypt so that you can join the online conversation if you want. Other than that, welcome today and thank you for joining us for a discussion on Egypt's possibly new constitution. Now, as of next month, Egyptians will probably be going to the polls to vote in public referendum on their second constitution in as many years. Now, there are similarities. At the moment, the draft constitution is with the interim president, and it will probably be released for public referendum supposedly in the middle of January. Now, there are similarities between this constitution and the 2012 one. In both cases, the drafting of the constitution, that the actual process was marred by an apparent domination of the process by one party or another, leading to allegations of exclusivity and resulting in a document that many people felt did not adequately represent them. In 2012, it was the overwhelmingly Islamist-dominated Constituent Assembly who shoved through a constitution that was dreadfully contested and was passed in public referendum with a very, very low political turnout of about 31%. This time, the domination of the process appears to be by the political factions who were involved in the ouster of former President Mohamed Morsi at the beginning of July, following a military coup that followed huge public demonstrations calling for his ouster. So there are Islamists involved in there were Islamists involved in the writing of this particular constitution, but they were mostly the Noor Party, which is a Salafist party that, did back the ouster, the Azhar. It contained no representatives of the Muslim Brotherhood, who had made up 43% of the previously elected parliament. This isn't surprising, since after the ouster of President Morsi, the vast majority of the leadership of the Brotherhood are currently languishing in prison. So there are a few points to be made, very quick points to be made about this constitution. The first is that the actual document in itself is a little bit of a surprise. The July 8th constitutional declaration by the interim president clearly called for amendments to the 2012 constitution. This new draft that we have has a preamble all its own. We have a brand new constitution, all 247 articles of it, Article 246 of which actually stipulates that any constitutional texts in the Constitution of 2012 have been annulled. So no one really knows what that's going to mean down the future. However, as with any document, there are pros and cons. There have been strides forward on freedoms of beliefs, on gender equality, excellent articles on education, on rights. On the con side, possibly in a reaction to the 2012 constitution, we have huge, essentially amount to power grabs by both the judiciary and the military. And one of the most contested articles is 234, which allows for the military trials of civilians. Now, it does list the cases in which case civilians may be tried by the military, but again, the wording is vague and does, as in many cases, leave it up to the law, which is very often in constitutions an open abuse of power. Now, at this point, I'm going to stop and turn it over to our two panelists who know a great deal more about this. We're very, very lucky to have them. We're going to have the panelists speak for about 15 minutes each, and then we'll open the floor to discussions. All right, so On my left, we have Dr. Sahar Aziz. Now, Sahar is the president of the Egyptian American Right to Law Association. She's she's a lawyer at Texas A&M. She has worked with the Office of Civil Affairs, Civil Rights and Civil Liberties at the Department of Homeland Security. On my right is Professor Nathan Brown, who most of you will already know. He is a noted scholar on Arab and Islamist movements and constitutional affairs, and we are extremely lucky to have them. So I'm going to hand the floor over to Professor Brown to start off with 15 minutes.
Okay, thank you very much, and thank you very much for having me. I mean, the Constitution can be read all kinds of different ways, but one of the things that it fundamentally is a legal document. And so in order to understand it, you need good legal reading. Therefore, the Hariri Center, the Atlantic Council have done good service by getting you a good lawyer to walk you through some of the provisions. I'm not the good lawyer. She is. And in fact, I'm not even a bad lawyer. I'm not a lawyer at all. I'm a political scientist, and so when I read these documents, I tend to give them a political reading in terms of focusing not so much on text, although you do have to actually read the text, but much more on political context. What kind of political context produced this document, and how is it likely to operate in the political context which actually exists? If you were, for instance, to drop the Constitution of Japan down in Egypt today, even if the letter of the law were faithfully applied, it would obviously operate very, very differently than in Japan. So I'm going to be focusing most of my remarks less on textual provisions and more on context of the existing institutions of the Egyptian state. And there's sort of an image of constitution writing, which an awful lot of us come in with the process, come in viewing the process, and in which constitutional drafters often draw upon. And it's the image of a moment of collective self-definition, a time when, in a sense, ordinary politics stops, and a time in which people sit down and talk not about what rules they want, but what rules they want to make about rules, how to make rules, and what are the fundamental structures that they want, what are the fundamental values of the society. I think that's a wonderful image of constitution writing, but it's a bad one. And it's a bad one because politics never stops. And this is not necessarily a moment when everybody sort of steps out of their normal political interest, but moment instead when the stakes are unusually high. And in fact, it's often a moment when everybody goes into politics with their elbows out a little bit more rather than a little bit less than normal. And I think that's what's happened a little bit in Egypt. When I take a look at sort of how this document arose, it arose obviously at a time of protracted political crisis, not simply the crisis of June and July 2013, but a crisis in Egyptian politics, which I think, despite all of the vast differences and polarization, a sense among many Egyptians that the political system is broken and needs to be fundamentally fixed, that needs some kind of constitutional expression. And it was broken largely because you had a leadership of the country, this is going back to 2011, that was not fundamentally accountable to the society. So the constitutional reform became a way for expressing the Constitution, the goals of all the tumult of Egyptian politics over the last couple years. But when I look at this specific constitution and the way that it was written in kind of an odd process. First, you had a committee of jurists who sat down and drafted some constitutional amendments, and like the Committee of 50, their instructions were to amend the Constitution, but what they did was essentially go over every single clause. It was an odd process because usually you would expect sort of the fundamental political understandings to be reached, and then you'd have the lawyers and jurists write it up rather than the other way around. In fact, what actually happened was that the Committee of 10 completed its work, handed over to the Committee of 50, which was supposed to review it, and the Committee of 50 said, "Thank you very much. and largely ignored that work, and instead started all over again. Again, taking the 2012 Constitution, you could say the 1971 Constitution, sort of an outline of topics that had to be addressed, but sort of taking a look at what they wanted to change, and therefore going through clause by clause and rewriting the document to the extent that it will be formally presented as a set of amendments, but also as a new constitution kind of at the same time. They're trying to find the exact wording for that. That Committee of 50 was supposed to be Egyptian society, all varieties of Egyptian society. What is remarkable to me about the body, the 50 people who were appointed to draft this constitution, was how many of those people in that Committee of 50 drew a salary from the Egyptian state. Some of them were formally representatives of specific state bodies. The security establishment, the Judiciary was represented very heavily in the Committee of 10. The military, el-Azhar, which is, after all, a state body. And then you had licensed unions, professional associations, again, that are not necessarily completely part of the state, but in a sense, state licensed bodies. And a very small number of politicians, representatives of political parties and political movements, and then a few sort of freestanding public intellectuals. That's who kind of wrote this document. And it is therefore not surprising to me that what they produced was a document that, when I take a look and read it, what really strikes me about this is the extent to which various state institutions have inserted into the document very strong institutional protections for themselves. So, el-Azhar, the Sheikh of el-Azhar, cannot be dismissed. The military, the Minister of Defense the military chooses its own Minister of Defense for the next 2 presidential terms, and there are other very, very strong guarantees of military independence. In a sense, the military courts, as I read this, essentially get to determine their own jurisdiction, or the military gets to determine the jurisdiction of military courts. That's effectively how this, I think, will operate. All other kinds of state institutions get these protections. The Constitutional Court gets written into the Constitution what it had earlier achieved by decree law issued by the SCAF, the Supreme Council of the Armed Forces, back in 2011. That is the ability to select its own president, which will make this a self-perpetuating court. Now, I'm not going to say that's good or bad, but it certainly is remarkable. Obviously, you have institutions that have a very strong sense of mission. All of these do, the security establishment, the military, el-Azhar, the judiciary, and some very strong and, I think, legitimate interest in ensuring that they can fulfill that mission without being micromanaged by, say, civilian politicians. But what it effectively means is that a lot of the big institutions of the Egyptian state are going to operate outside of any mechanisms of accountability whatsoever. And so this is an image, the image that I've used before, is this is not the society constituting a state. This is a state that is constituting itself. And that can have some implications for how Egyptian politics operates in the future. When I take a look at how this will operate, I actually see 2 possible scenarios. One is it will look like Egypt today, only more so. Right now, you do have a civilian cabinet, and a civilian cabinet that in many ways is one of the more impressive. You look at the individuals within it that Egypt has produced. If you were to pick an all-star team, I'm sorry, I'm an American, so I deal with sports metaphors. I just have to. You might get many members of this cabinet on it. But it's also one that feels clearly a little bit politically disempowered. The chief decisions are being made. Sometimes you will read interviews with cabinet ministers in which they almost sound as if they're spectators describing policy that they're witnessing rather than making. You have a set of decisions that are being made, and it's not quite clear by whom, but the fundamental decisions on all kinds of issues, especially on issues of economic reform, are simply being postponed because nobody is really in a position to take a great risk or responsibility moving forward in any particular way. And those institutions of the state are operating, in a sense, not under any sort of political oversight by the existing cabinet. So you could have a permanent institutionalization of this system, and one in which I think would probably serve Egypt poorly, especially in the situation right now when you have kind of not simply the military playing such a strong role, but a security establishment that, I'll drop diplomacy here, is really out of control. Absolutely out of control, and there's no real mechanisms. I think for instance, one of the constitutional provisions in this document is to create a police council. It was a participation of the Minister of Interior, but the Minister of Interior always comes from the security establishment, and it gets to be consulted on any law affecting the police. And effectively what that does will run security sector reform through the existing security establishment, which is not necessarily going to be the most effective mechanism, I think, for ensuring the kind of security sector reform that many Egyptians think is necessary. So that would be one scenario of how this would operate. There is a second scenario. And that would be the re-emergence of a strong presidency. When I take a look at these institutions, they've really protected themselves in some ways, not simply from the parliament, but in some ways they could be protecting themselves from the presidency as well. But if we think back to the Mubarack presidency, one thing that was remarkable to me about this was that Egypt, and even to some extent, to a lesser extent, the Sadat presidency, you actually had strong institutions in Egypt, but ones that were ultimately deferential to the presidency. All lines of command went to the presidency. This was often done formally, but sometimes it was done in ways that were not always completely obvious on paper, through key appointments, or through kind of co-opting. I mean, in a sense, the judiciary in this period had a strong guarantees of independence, but simply by ways in which the Ministry of Justice managed to sort of dole out benefits, you could have kind of the judiciary sometimes reined in a little bit. You would have key appointments. The President of the Constitutional Court was a direct presidential appointment, the Prosecutor General, and so on. So you would have these kinds of mechanisms for bringing these state institutions under control. Those mechanisms would be weakened under this constitution, but I still think that with a particularly powerful president, you could see that. And now I'm going to stop talking in terms of titles and institutions and start talking proper names. If General Abdel Fattah al-Sisi runs for president and occupies the presidency, I think this constitution will work extremely differently, because suddenly you will have a president who has very strong democratic legitimacy. I'm assuming he would win in a landslide. The only question is, would there be anybody who would run against him? Probably a very weak, divided, and scattered parliament among all kinds of independents and political parties that really don't have a strong electoral base, and a presidency that is therefore anchored. I mean, presumably he would resign his military rank and run as a civilian, but still one who comes from the military establishment. And then what you have is a system in which you might have a political leadership that is capable of launching clear policy directions and taking hard decisions, but also a re-emergence of presidential autocracy. Sanctioned this time by perhaps a democratic election, but essentially a re-emergence of the Mubarak era with popularity added. So those are the two main scenarios, at least for the short term. Let me just close by offering a couple possibilities of ways that, at least over the long term, a couple kind of trap doors towards, I would say, a more or less autocratic order within this Constitution. One is the provision within the Constitution, and Sahar, you may say more about this, but it writes in international human rights documents into Egyptian law. And the fact is that any constitution, relies on a complex legislative framework in order to be implemented. This constitution especially does, because of the amount that it defers to legislation. So you've got essentially, even where there are liberal elements in the constitution, it's being superimposed on a fairly authoritarian legal order. What this clause could do would be to give to some courts, and I would, especially the Constitutional Court, but conceivably the administrative courts as well, license to start measuring Egyptian laws against international human rights standards. Would they do that? I think, given strong and self-perpetuating courts, you could see that emerge over the long run. In a sense, the Constitutional Court, like that emerged in Egypt in the 80s and 90s, that found a less direct way to write in international human rights ideas, I would say, or standards into its decisions. So what it would depend on would be a judiciary or parts of the judiciary, key judicial actors that saw it within their mission to do that, operating year after year after year, it might be able to sort of affect some change in the Egyptian legal order as a result. And there's a second possibility as well, but it's off to a bad start. The world is full of constitutions that were written in horrible circumstances. Okay, countries where everything's going along fine generally don't write new constitutions. So it's not unusual to see a constitution, I can't remember the word you said, dreadfully controversial, or I can't remember the phrase that Mirette used, but something like that. I mean, constitutions usually take place or usually drafted in moments of political crisis or following moments of political crisis. And they very often have kind of dirty and ugly births, or contain dirty and ugly compromises. And and Americans in the room don't have to be reminded of the dirty and ugly compromises that were in our document, but that's not unusual. Constitutions, I think, can sort of take on a little bit of life of their own when they seem inevitable, and when various political actors begin to sort of orient themselves around that. If you had a political system that was just clearly going to be there, and the excluded groups who are clearly Islamist, ultimately deciding, look, we ran under Mubarak's constitution, we can run under this constitution as well. Yes, the system is kind of stacked against us in all kinds of ways, but we can sort of participate. The fact is that Egypt's longest living constitution, the constitution in 1923, was rejected by the country's largest political party at the time, the Wafd Party, which very soon decided, well, we might as well run anyway, and then started winning elections, and in a sense giving the 1923 constitution probably the status of being not simply the longest lived Egyptian constitution, but also the one with probably the greatest legitimacy. Something like that could happen. But, as I say, it's off to a bad start. Because it seems to me that both Egypt's current leadership and the leadership of the Muslim Brotherhood, such as it is starting off in a very, very different kind of direction. One that will leave everybody angry and embittered and essentially questioning each other's patriotism, questioning each other, sometimes even their humanity. So is this constitution going to be a way of healing Egypt's political wounds? No. Period. If Egypt's political wounds eventually heal on their own, does this constitution, is there enough of a possibility for liberal and democratic politics to emerge in the very long run? Unlikely, but it's not impossible. And I guess I'll leave that to pass for a happy ending.
Thank you. And on that bright note, we are going to go over to Sahar, who's going to say something equally bright.
Thank you very much. I want to thank Mirette and everyone at the Atlantic Council for inviting me. It's a pleasure to be here, and it's an honor to be on the panel with Professor Brown. So I want to focus more on some of the text and kind of some of the legal gymnastics that I think is occurring and always occurs whenever you're dealing with the law. So as Professor Brown mentioned, is, constitutions or any legal document is really only as good or as valuable as its legitimacy and its credibility. Otherwise, all it is just ink on a piece of paper that really has no value and no effect or minimal effect on society. So if you look as far back as the 1971 Constitution, in fact, facially, it appeared relatively progressive. I mean, there were rights in the 1971 Constitution. You had the right of innocence until proven guilty, the right to access to courts regardless of your economic status, freedom of expression, belief, there was right to equality. I mean, I can go down the list. So it's not that all of these kind of more progressive, liberal, universal rights were absent from the 1971 Constitution. It's just that they weren't enforced. And they also had what we call, as a legal term of art, clawback provisions. So it would have this very, very nicely worded phrase of giving you the right to expression, assembly, belief, and then it would have a little provision that said, as regulated by law. And that would essentially provide the National Democratic Party the right to legislate around those rights, and usually to dilute them and minimize them in some way. The other two problems were in terms of the value of these rights, the legitimacy and the enforcement of these rights, was the absence of consistent implementation. There was very selective enforcement, is very inconsistent, and also more dangerously were these exceptional courts, which continue to exist today. Now, the good news is that at least the state security courts jurisdictions have been reined in because of the emergency law provision, which I'll get into in a minute. But when you look at a constitution, it's not so much what you see, it's the hidden that you're looking for, what's between the lines, and how can lawyers, sophisticated jurists, manipulate the text in order to usually perpetuate some kind of political agenda. And that's exactly why you have the separation of powers, as you assume that the executive branch wants as much power as possible and discretion. You assume the parliament does, and then you hope that the judiciary can be neutral, arbitrary, and keep them in check. So it's not so much that we have the perfect system here. I mean, we've seen our Congress and our executive branch. It's just that, one, we follow the law, it has legitimacy, and there are structural aspects of the law that restrain these respective branches from overreaching. Okay, so I want to talk about some examples of these clawback provisions. For example, the freedom of belief in 2012 Constitution, which was based on the 1971 Constitution, Article 43, state shall guarantee freedom to practice religious rites and places of worship for the divine religions. Divine religions means the Abrahamic religion, so there's still that limitation in terms of protection for Muslims, Jews, and Christians. And so the Baha'is did not get their requests for recognition or protection in this Constitution, nor in the past. And so that provision is still there, right organized by law. So when you read through this draft Constitution, look for that clawback provision, and that's a red flag to say, okay, this could theoretically be politically manipulated. The good news is freedom of expression. That used to have the clawback provision of the right to express opinion, disseminate it through various means within the limits of the law. That was removed into 2013, so that's, I think, good news. The freedom of assembly, not good news, and that's where you have the anti-protest law. So public meetings, processions, gatherings, again, protected fundamental freedom within the limits of the law. And so then you have this, what I think is an illegitimate anti-protest law, primarily, not necessarily because of the content, which I do take issue with, but also the means in which it was passed. So you have an interim president who was not elected, who arguably, is really there because the military wants him there, and he passed this sweeping anti-protest law that essentially is viewed as a mechanism to both impede the Muslim Brotherhood from re-entering politics or having some kind of influence, but also to quash the the liberals and the youth activists and the revolutionaries who originally started the revolution. And so you're seeing that now with what happened with the No to Military Trials protesters and April 6th movement. So you're seeing now this switch or this expansion of what I think are repressive measures. But the point is that's authorized by this new constitution, or this new draft constitution. The other issue to keep track of is, so the good news is you cannot be, or a journalist cannot be incarcerated for publishing certain things, because that was a big tool for censoring the media and intimidating journalists. However, defamation and libel is still very broadly defined, and you can be punishable by incarceration. And the reason why that matters is, again, if you can imprison someone under the auspices of violating defamation laws or libel laws, which is usually directed at journalists, then that's an indirect way to repress the press. Right? So you don't have to have something direct that is open censorship, but it's a much more indirect way. And of course, we all know that the press is extremely important in any kind of democratic, open society that will evolve. So then I want to talk about the emergency law, which I think is very important. And this is probably, to me, the most optimistic part of this Constitution, and I'm still looking for ways that it might be worked around by political actors. But under Article 148 of the 1971 Constitution, the President had very broad authority to issue emergency law, in other words, to call for a state of emergency. And he could call it for whatever period he wanted, 2 years, 5 years. He could renew it. He had to get the lower house's approval, and then it would be renewed for the same period again. And essentially that happened for 30 years under Mabrouk. So when Sadat was assassinated, Egypt had a state of emergency. I think that was legitimate, but not for 30 years. But because the National Democratic Party and the parliament was pretty much in his pocket, Mubarack's pocket, he could just continue to renew it for the same period of time. So why do we care about that from a rule of law perspective? Well, when the emergency is in place, when there is a state of emergency, the president can limit all individual freedoms with regard to assembly, association, expression. The president may arrest, detain suspected persons of those that are alleged to endanger the public order, which is a very broad area, censor the press, all means of expression, and most importantly, the president can then can require suspects or can, refer suspects to state security courts, which are kind of the emergency law courts, where you have no due process rights. So all the rights you otherwise are supposed to have under a regular criminal justice system, you don't have from, whether it's the right to an attorney, whether it's the right to be known to appeal your sentence, for example. You can't appeal it within the traditional legal court system, the civilian judiciary, such as through the Court of Cassation system. And also the president can refer any crime to emergency to the state security court. So the point is that once security emergency law is in place, the Constitution, at least the individual rights portions and the due process rights portions of the Constitution, are pretty much null and void. And it is the one-way ticket to just eliminate that aspect of the Constitution. So that's why emergency law is such an important issue, particularly in Egypt in light of its history. So the good news is that Article 154 of this draft Constitution requires now that if the president wants to call for a state of emergency, that the House, now Egypt is only going to have a lower house, the People's Assembly, they're not going to have the Short Council, and that the People's Assembly must approve the emergency law, and it cannot be for more than 3 months, and it can be extended for the same amount of time, 3 months, but only upon a 2/3 majority vote of the House. So that is very, very restrained. Now, arguably, if the parliament and the president are pretty much all one party and that party has a majority in the parliament, in theory, it could then just be renewed every 3 months perpetually. So that is one way you could get around it, but I'll leave it to Professor Brown to speculate whether that is a possibility in the future. But at the very least, it does restrain it. But keep an eye on that emergency law provision and those rights, because that is one way to unilaterally eliminate individual rights that are protected by the Constitution. So the other problem is military courts, which you've seen a lot of coverage about that because you've had these civil society groups that are identified as liberals, progressive, more kind of westernized definitions of individual rights. And they have been protesting it because, so let me kind of give you the history. In 1971 Constitution, Article 183, there was no mention of trials of civilians at all. They just didn't discuss it. However, in 2012, Article 198, it allows for crimes that, quote, harm the armed forces. So if you are a civilian and you are accused of a crime that harmed the armed forces, you could be tried by a military court. That is extremely broad. So you can thank the Muslim Brotherhood for that. And many civil society actors are very upset with them for that. And now in Article 204, they kept the provision. However, they attempted, they meaning, I guess, the Committee of 50 in the military, because this was a very contested issue and the military was pushing for it to protect this right to try civilians in their courts, is they now have phrased harmed more detailed. In other words, they've narrowed it to whatever falls under their authority stipulated military or border zones, equipment, vehicles, weapons, ammunition, documents, military secrets, public funds, or military factories, or personnel by performance of their duties. When you read it, you think, okay, well, it sounds pretty narrow, it sounds pretty limited. The problem is that the military, supposedly, we don't know, has about 40% of the economy. It's kind of a shadow economy, which we'll never know exactly where the money goes because this new constitution only requires them to submit a line item in the budget that says their total budget, which includes everything from the kind of bona fide military activities to the economic activities. And so some of the concerns of civil society was, well, if I get into a fight with a personnel, maybe that officially works for the military in a gas station, in a factory, in an economic enterprise, I can be tried in a military court. And that is a way to censor me if I want to have any kind of dissent regarding a more kind of economic, political, social issue as opposed to a bona fide national security issue. So the language is still highly problematic, and in light of the fact that 12,000 civilians, now this was under, we can thank the SCAF for that, between February 11th, 2000, I don't know if it's February, but between the revolution and when Morsi got elected, 12,000 civilians were tried in military courts. That's when the Supreme Council of Armed Forces were in power. Under Morsi, it continued. We don't know how many people, but as you can see, this is actually worse, exponentially worse. And to the extent that a former military general and former minister of defense becomes the president of Egypt, that might become more normalized. So again, that's something that unfortunately is not positive. And I just want to highlight a few other things that I do think are positive, but again, only as insofar as they're actually enforced. So the first is Article 68, which I'm very pleased to have read or to have found was kept. This was actually also in 2012 Constitution, which is the right to information, access to information. It's very difficult to have a functional democracy if you have no transparency. It's very difficult to allow the press and civil society to be effective in being, if you want to call it a fourth branch of government that oversees the other three branches if they have no information. And citizens have no information. It's easier to manipulate the public. It's easier to lie to the public. It's easier to use rumors and conspiracy theories to manipulate the public. And so Egypt does not have a freedom of information law. This is something that we're working on at the Egyptian Rule of Law Association in supporting, and we're very hopeful that a new law will be passed pursuant to Article 68. And it also requires that the agencies and the government has to actually protect these documents, because what governments do, including here, is they, if the documents don't exist, then you can't access them. So you have to also have a preservation right. So those of you concerned with that, keep your eye on this forthcoming draft law on FOIA, because it's going to be very important. Article 11 allows for appointments of women to judicial bodies. I think that's a positive development. As you may know, it was only in 2007 that women were even permitted to be judges, and that was only in the administrative courts. And now, hopefully, that will be expanded, but based on my experience in Egypt, this will be a very major cultural battle. But at least the Constitution protects it. And the Supreme Constitutional Court, I think this is important because there was certainly a war of attrition between the Supreme Constitutional Court and Morsi's regime. So the Supreme Constitutional Court now gets to elect its own president. Before, it was the president that did so. And one can argue that one of the reasons why it may have become less independent in the last 10 years was because Mabrouk was very, very proactive in selecting who that president of the Supreme Constitutional Court was, and there was certainly a political litmus test. Also, the Prosecutor General will now be selected by a Supreme Judicial Council. It doesn't seem clear who's going to be leading and be members in this Supreme Judicial Council, something to keep an eye out for because they're going to have a lot of power. So there is a lot more judicial independence on paper, but again, politically, who those actors are and how they are selected is very important, because what Mubarack would do is he would make sure he selected the top, particularly in the judiciary, and then they would discipline through enumeration, through secondments, through promotions and disciplining proceedings in getting the judiciary to cooperate and not be too politically controversial. And I guess the last thing I want to identify is, because I wrote a piece on this called Revolution Without Reform, is women in the parliament and women in elected positions. There was a quota in 2000 that was imposed in 2005. It was kind of considered the Suzanne Mubarak law, which is a pejorative in Egypt, and where they required 64 members of the lower house to be women. And that increased the percentage from, I think, 3 to 5% to 12%. That was removed by the Supreme Council of Armed Forces after the revolution. So then the next parliament, which was dominated by the Muslim Brotherhood, I believe had like 11 women, most of whom were very far right of the Muslim Brotherhood. Like even within the Muslim Brotherhood, they were very far right. So there was very minimal female representation and diverse views of women's representation. That still doesn't exist. There's no quota. However, the local councils now, there's a quota of 25% must be women, 25% must be youth. It's unclear how much power the local councils have and whether that is actually a meaningful incorporation. I don't know the answer to that, but I think that's important to know. And this is very fascinating, is Article 102 allows the president to appoint up to 5% members of the parliament subject to a law that determines procedures and criteria for nominees. So that may be an escape route. It may be kind of a valve to allow the president could do two things with it. The president could either use it as a mechanism to appoint underrepresented groups such as women, religious minorities, or could use it to bolster his political party's numbers. But it can be a sword or a shield depending on how you look at it. And I will end there and then we can talk more about specific details. Thank you.
Thank you so much to both of our panelists. We're going to start taking questions. I'm going to, because I get to be moderator, I get to ask the first question and then we will take questions from each other. This is a question to Nathan and to Sahar, really. So it's easy to see the dangers in too much power going back to the military, to the security sectors. I mean, those are easy. When we talk about the judiciary, the judiciary in Egypt has on-off, traditionally had a fairly independent role, although that's been severely shaken over the past year and a half. What are the dangers of having a judiciary that tends to police itself and is self-perpetuating? Shall we start with me?
Yeah, I mean, obviously you want some degree of judicial independence. So the very idea of judicial independence is not the problem. The way that most democracies handle this is to have some kind of, some sort of insulation from the day-to-day political process. So there is still some kind of oversight, democratic oversight, but it's not a partisan oversight. So if you're appointing judges, they get very long terms. Here they get lifelong, federal judges get lifelong terms, or in many countries they get 10-year terms that are not renewable, so they don't have to curry favor. You need supermajorities for their appointments, so that you have to have a broad consensus supporting them. Those are the sorts of devices that are used. Now in Egypt, the judiciary has traditionally pressed for full independence, going beyond that. And in a sense, partly for a good reason, because they took a look at the political system as it existed. And if you'd use those kinds of mechanisms in Egypt, the Nasser period when there was a one-party state, you were not going to get any real judicial independence if you used the mechanisms that I just talked about. And so what they really pressed for was full judicial independence. And it looks to me like they've basically got it. There are some There are some possible loopholes, as Sahar mentioned, the fact that the Supreme Judicial Council is defined now in legislation, but it's not defined in the Constitution. So you could perhaps play around with the composition of that. But I don't expect that actually to happen immediately, because the judiciary is now an institution that has proven its worth to, I think, the core institutions of state. So now, with all that as background, what's the problem? Well, a judiciary that is completely unaccountable can go off in any kind of directions. There is already a marked tendency within the judiciary to, in a sense, be a little bit of a self-perpetuating body. If you get into a conversation with an Egyptian judge, it's not uncommon to say, okay, so how did you get interested in being a judge? Well, my father was a judge, my grandfather was a judge, my uncle's a judge, and my aunt works for the State Cases Authority, which was a judicial type body where women were employed and so on. It sort of creates almost a caste, a judicial caste. And the judiciary, there's no guarantee of what direction that it will go in. In a sense, what happened in the 1980s and 1990s was you had a constitutional court that by tradition became self-perpetuating, because a president always appointed the most senior member as Chief Justice. Only when the court got out of control from his perspective did he start bringing in justices from outside the court to control it. At that time, the court did develop a very strong liberal jurisprudence in some areas. It also developed a jurisprudence that I think went very much against the 1971 Constitution in spirit, because their liberalism extended to the economic realm. The 1971 Constitution was a socialist document. So on their own, they started basically saying, well, we'll just kind of read past those socialist provisions. And in a sense, that was a core political decision that was made by an unaccountable judiciary. In retrospect, certainly from a liberal perspective, the Supreme Constitutional Court of the 1980s and 1990s was one which did effect some real changes in Egyptian political life in a more liberal direction, but it did so, but it could have gone off in any number of directions. And I would also say that the judiciary in Egypt tends to be very, very protective of its own prerogatives. My own reading of the court's dissolution in Parliament in 2012 was that it was not a move by the Supreme Constitutional Court to effect the orders of the Supreme Council of the Armed Forces. It was not an automatic step like that. However, the Parliament at the time was discussing the law by which the Constitutional Court was written. So it was an act of as they saw it, an act of self-defense. Or the analogy that I like to use, it was a shootout. Whoever drew their gun first won, and the Constitutional Court pulled out its gun and shot the Parliament dead before it could be shot dead by the Parliament. And that's the sort of thing that can happen as well, as a judiciary that takes such a very strong sense of its own prerogatives that it begins to act in almost an authoritarian manner.
Thank you. Did you want to add something to that?
Yeah. Well, so, when you're an attorney and a law professor in the US, you're obviously biased by the system in which you were trained. And when you think of what is it that makes our judiciary, I think, relatively independent, much of it is very cultural and to some extent how you get in, although we do have a political role, or there's a role for political actors in how you become a judge. For example, I strongly disagree with the fact that judges are elected at the state level, and including in the state of Texas where I teach, because I think that they are amenable to political influence. It becomes kind of a legislative role, although nobody talks about it that way, but people know, lawyers know when you go before certain judges that were elected that they are going to be more conservative or more liberal on certain issues. And then there's just a lot of wordsmithing and gamesmanship in how they write their opinions. So we certainly don't have a perfect system. So one is how do you get into the judiciary? There's been many calls for reforming that. Right now it is very wasta based, which is pretty much how most of Egypt's economy works. Wasta meaning who you know, your connection. And so there needs to be a reform of a merit-based system of how you actually become a judge. I agree with the life tenure. I think you also need to make sure you pay them adequately so that they're not as vulnerable and susceptible to bribery, because sometimes you can have kind of micro compromises and that eventually accumulate to compromise the entire independence or the integrity of the judicial system. And also, and this is something that I find very strange, but this is because of the civil law system versus the common law, is it's very bizarre for me as an American lawyer to see the prosecutor general as a judicial member, a member of the judiciary. For us, the attorney general is an executive branch officer, represents the president of the United States, and so there is this perceived conflict of interest from our perspective here of how can this prosecutor general be a member of the judiciary. And I suspect that's not going to change because this is deeply rooted and based on the French system. But the reason why I think that's significant is, you know, to the extent that the prosecutor general's role is to enforce the law, and it's not an adjudicative role, and so there is, it's just a major conflict of interest. And then finally, which I think this Constitution does address, is the Minister of Interior's control over the judiciary, because historically the Minister of Interior would use things such as control over the inspection or the disciplinary boards for judges. So they would use carrot and sticks. So that was the stick. The carrot was secondments, which are very profitable, very lucrative. When a judge gets sent to an embassy abroad or gets sent to work for an international organization, their salary multiplies. It's very prestigious and it's also a very good lifestyle. Or you could end up being sent down south in Egypt to a very small rural town as opposed to maybe in Cairo where you might prefer to live and your family lives there. So there's different ways that you can discipline judges that are indirect. So the more you can remove all of those means between the executive branches controlling it over the judiciary. And then finally, I think it's culture. I think that judges have to have a self-interest, a collective interest to preserve their independence, their integrity, and their legitimacy within society, and they'll self-regulate. And so I am biased that I think self-regulation is the optimal choice among other choices. It's not perfect, but it's better than the other options.
Should we start taking questions over at the back? If you could just let us know who you are as well, please.
Honor de Borgraf, CSIS.
Thank you.
I was wondering, since we live in the age of social media, whether our two presenters could summarize their positions in 140 characters or less.
Okay. All right, well, we'll take several at a time to allow
Professors
people
are not trained to do that.
Yes. Okay. So.
Hi, Ryan Sudo, Tahrir Institute. Sahar, I was wondering if you could speak on Article 31 and your thoughts on that.
Okay,
Thank you.
I don't have it memorized. Tell me which are, I don't have the entire Constitution memorized.
Sorry, it's about the security of the information space and how it's framed as part of the national economy and security.
Wait, that's not one, say that again?
Article 31, the security of the information space is an integral part of the system of national economy and security.
Yeah, I haven't looked into that one.
Okay.
It refers to freedom of expression. Security of information. What may be released and what may not be released. It's a gag order.
I haven't looked into that one deep enough to give you something that's informed.
Okay. All right.
Hi, I'm Mirette with the Middle East Institute. I think that some of the revolutionaries and liberals out there in Egypt are probably just as unhappy, if not unhappier, than they were on January 24th, 2011. So I was wondering if you all could speak to what sort of constraints this new constitution places on their ability to voice some of the same concerns, as well as their, and this is maybe a little bit out of the realm of what we're talking about, but their kind of psyche and the wherewithal that, recent events have taken a toll on their ability to do so to begin with.
So I'll just make a few comments. One is I think we've learned that to use a vernacular term, where the rubber hits the road is the law, not necessarily the Constitution. So the Constitution provides many of these rights in a very broad sense, freedom of assembly, freedom of expression, etc. But they're now pushing for legislating the limits of those laws. I think that it doesn't bode well, what we saw with the anti-protest law. So the fight is going to be shifting into the legislative round, which is, arguably how that is the realm in which you negotiate the reinterpretation of a constitution, is through the legislative branch and then through the courts interpreting it. I am, again, biased as an American lawyer, that I find Egypt's constitution to be unbelievably lengthy and extremely detailed, and that's not something that we in America are accustomed to, because the details are usually through the legislative process, and it can then evolve, and also then the courts interpret it and set the limits. Here's the limit, and even those limits evolve based on society. So that's just to say that I think the revolutionaries and the youth and these groups who have used the street to protest, for better or worse, are going to need to become more experienced and have more political acumen in going through more formal political processes, such as building political parties, campaigning, going through the election process, becoming members of parliament, and becoming part of the system, which I know is not how they were originally formed. They were formed as being outside the system. And so, if I'm going to kind of take a government a stability approach here, is perhaps the best option for them to be effective is to institutionalize, to become civil society actors that are heavy-hitting, established, entrenched watchdog groups, to have political parties that actually can mobilize and use elections and use kind of the formalistic processes. As long as, assuming that this new government does not play the same Mubarak tactics and games that they did before, where you couldn't have an independent civil society, where you couldn't have an influential political party. And I don't know if that's going to happen. I mean, if we had this conversation 6 months ago, we would have a different conversation about Egypt. And in the next 6 months, who knows what we'll be talking about. But, and I know that's not what they want to hear, because it's not very exciting. I think it's very exciting to protest and to have a revolution, but I think that time and the Egyptian people they have revolutionary fatigue, and I think they want to start institutionalizing things and shifting reform through more sustainable means and less disruptive means.
In other words, it's a long haul. Nathan, would you like to?
Yeah. Let me take the 140 character challenge.
I was going to do that at the end, but okay.
But I'm going to bring it in. I'm going to link it in. I'm hoping nobody's actually counting characters, because I might go over 140. But it's key parts of the Egyptian state got the constitution they wanted. That's my bottom line message. Now, how is it relevant to this question? I would kind of amplify what Sahar said. The legal framework here is what's relevant. The protest law is really what's causing much more of a fuss than the constitutional text itself, and that's what kind of kicked up a little bit of a storm. Now, is this protest law consistent with the Constitution? I think you could probably make a strong constitutional challenge to the protest law, based on some articles about in the Constitution, certainly the way that the protest law has been implemented. I would think that this would be the worst time in the world to lodge such a constitutional challenge, when the core institutions of state are just reestablishing themselves. In other words, what I would worry about right now is that you'd get a constitutional court that would say, do we vote for chaos or do we uphold this protest law? The kinds of legal guarantees that are possible to read in this Constitution, they are there. But there's a sort of things that would only emerge over a long period of time in a much calmer atmosphere. They're not going to emerge right away. So to place any hope in this constitutional document, and my guess is in the constitutional process, right now is going to be a misplaced hope.
Thank you. And just before we take the next question, just to follow up to what Sahar said, of the 247 articles that are in this constitution, which is possibly the longest I've ever read, I think.
Well, they are longer, yeah.
But it's the longest article. Of the 247 articles, most of them will still refer you to the legislation, so you still have nowhere to go. So, sorry.
Can I take the 140 word
Yes.
character? I don't think
Fine,
I'm going
we're
to try
do it at
this.
the end, but
You're going to have to use like shorten it. Egypt Constitution, positive step forward, but be weary of loopholes and selective enforcement.
Okay, thank you. Thank you. Peter, that's right, and then... So.
I'm Peter Mandeville from George Mason University and the Brookings Institution. We've heard a couple of mentions of the involvement of al-Azhar in this process, but I'm wondering if both of you might just reflect a little bit on the position of Islam in the Constitution more broadly, particularly as compared to its position in the two most recent versions of the Constitution, and to sort of leverage in a second question, what resources or tools exist in this new Constitution that would permit those that might seek to do so to exclude particular groups from politics?
Do you want to go first?
Yeah, sure. The second question is easy. A ban on religious parties, okay? So, but it's a little bit more complicated than that, because the Freedom and Justice Party is still a legal party, and all its leadership is arrested and so forth and so on, but it's still a legal party. The Hizb ut-Noor, the Salafi party, is still a legal party, and they were given license at a time when there was a ban on religious parties in law. So, when they applied, they didn't say we are a religious party, we're just a normal political party, and it just so happens that we have a lot of men with beards in our founding organization, but, and they got in. Under the Constitution, the same provision also says that no party can be dissolved without a court order. So my guess is you're going to see a lot of lawsuits against these parties, and then we don't know the fate of those parties, and my guess is some of the judiciary does have some strong independent elements, but the public mood definitely does have some impact on the pattern of judicial decisions. So a lot of depends on kind of what court, under what kind of political circumstances get these cases. More generally on the religious provisions, I mean, there's one strong difference between the 2012 and 2013 Constitution is just tone, okay? So the 2012 Constitution had very kind of conservative social language. It wasn't quite clear what that would mean in practice. There were attempts to kind of give it a little bit of teeth, but as I read this, it was not clear that it would really have much practical impact. There were two provisions that went much farther. Okay, there was one that mandated that al-Azhar be consulted in matters of the Sharia, and that has been taken out. I don't think that actually will make that much of a difference, because al-Azhar will give its opinion, and no matter what, and it will be politically very difficult to ignore al-Azhar's opinion. Al-Azhar, I think, is emerging as a much stronger institution as a result of this whole political process. And the second was Article 219, which is the famous article I can't quote because it's virtually untranslatable, and even if you take a look at the Arabic, and you really need a training in Islamic law to understand even what these terms mean. It is not clear what that article would have meant in practice. We never found out, but it attempted to define the principles of the Islamic Sharia. I'm not sure it would have had that much legal effect. That's a guess that it would not have had much legal effect. And in fact, the only jurisprudence we saw from the Constitutional Court after the 2012 Constitution on an Islamic legal question was one where they showed no change in their orientation towards the principles of the Islamic Sharia. So it got dropped out. It was a very important symbolic step. I'm not sure it's an important legal step. Overall, I mean, I would just come back to the point that I made about al-Azhar. What is going on during this entire process, I think, is a consolidation of the religious establishment. That's taking place institutionally, it's taking place in law, to some extent it's taking place in the constitutional text, although much less so. And so you're really seeing, I think, a much stronger state role in defining and regulating and policing religion than existed before. Religious broadcasters, independent religious broadcasters, have been shut down, and so on. There's an attempt by the Ministry of Religious Affairs to have much more control over the religious at the same time as it's becoming a more autonomous body. The analogy that I like to use is what Egypt seems to be constructing is Italy in 1950. Okay, there's a church that kind of has to be kind of consulted as this powerful political actor. It's not really accountable to any kind of body. Or Ireland in 1950, kind of the same kind of thing. Is this very, very powerful and unified political presence with a strong leadership. The last time I made this analogy, there was an Italian in the audience who said I completely misunderstood Italian history. So if there's any Italians or Irish in the audience, I apologize. It's the best I can come up with.
Thank you.
So I'm not an expert on al-Azhar, but when I saw these provisions, first I was pleased to see that phrase was removed, the removal of the consultative role. I thought that was not good for the al-Azhar or good for a civilian state. So even if it effectively wouldn't have had much of an impact, it still was not a good idea to keep it in there. I think what's interesting about including it, so on the one hand, I think it's a positive development to establish their independence, because to the extent that they have influence, it's, I think, better for the state and for the people not to have the state trying to control religious institutions, which in a country like Egypt have a lot of impact normatively and socially. As you know, it's a very devout country. However, I worry because of its consolidation of power that if it does become under the tutelage of the state, of the executive branch, even if it's unofficially, informally, it will be very, very powerful. Second, so there's that risk. It's kind of a blessing and a curse at the same time. It's also going to probably shift kind of the battleground of ideological fights of what is the right Islam, which is in every religion. It's going to shift it there. And so to the extent the Brotherhood or the Salafis or all these other various groups want to have some systemic influence, they will likely try to strategically infiltrate and try to gain influence through al-Azhar, and that will now become the political battlefield for that. And I don't know, it's too early to tell what that means exactly, but this centralization can be very dangerous depending on who's at the apex of it. So in some ways they may have invited quite a lot of trouble for themselves and much more intervention by these different Islamic groups who otherwise would have kind of done their own thing, been fringe, would have had to rely on populist support as opposed to going through this institutional powerhouse if they can take it over the way they do with syndicates. So I think that's something to keep in mind.
Thank you, sir. Yeah.
My name is Ali Soliman. I'm a consulting engineer. I have a question to Dr. Brown, Professor Brown, regarding the similarity, which the way I understood it, that the two committees, the committee that wrote the 2012 and 2013 were similar. For many Egyptians, and I'm one of them, I see it to be the two committees are not different. We had an election in 2012, we had an elected parliament, and then the elected body came up with a committee, 100 people. And they held meetings, they were all televised, but the opposite happened since July 3rd, where we had no elections. Everything since July 3rd was non-democratic, and just we had a committee of 50 people. They may be intellectual people and represent the society, but we have a large group. That's the Muslim Brotherhood, and you said they may agree to work with this as they did with the Mubarak constitution, but they are not there today. Their leaders are in jail. Some of them are in the grave after the massacre of Rabaa and other places in downtown Cairo. Some are hiding because of fear of arrest. So how could they be, they're not a part at all. They're not present to say their word or even contribute to the constitution or even to the vote. So in the introduction, it was mentioned that Egyptians are going to vote. Actually, half the Egyptians are going to vote because some Egyptians are boycotting and some are not going to just vote, period. So I would like you to comment on this similarity. Do you see similarity between the two committees and the 2012 constitution was in the referendum, all Egyptians agreed to vote, including the liberals, and they participated, but the result came 64%, which is a good result for a constitution that everybody participated, but this time only one party is going, and you said a key group has gotten what they wanted. So if you can just comment on this issue. That's how similar or how different or how democratic or non-democratic. Thank you.
Yeah. I mean, just a quick modification on the Brotherhood itself. I do not expect them to accept this constitution anytime soon. They may eventually, but that would be over the long term, not over the short term. The initial indications we see are very much the other way. In terms of comparing the two processes, it is true that the 2012 Constitution was written in a way that essentially followed these democratic steps: the constitutional referendum of March 2011, the election of the parliament, the election by the parliament of 100 members, the election of the parliament of 100 members a second time when the first one got dissolved, and then the referendum. Absolutely. When I look at it, and this is an appointed committee. When I look at the political process, what I see was that for whatever reason, and there are some good reasons and bad reasons, that Constitutional Assembly back in 2012, by the time it finished writing the document, was essentially an Islamist-dominated body in which they came to an understanding with certain key state institutions. That's what produced the document. And in 2013, you had a process in which I think the state institutions even played, they were, instead of the junior partner, now they're the senior partner. In both cases, what is absolutely missing is some kind of social consensus among civilian political forces outside of the state that is supporting the document. So the 2012 Constitution, whatever its democratic legitimacy in purely objective terms, ran into real trouble when Morsi ran into trouble. There was no constitution. When Morsi said, look, I am the legitimate president of Egypt and there are constitutional procedures that we have to follow, that was an argument that had zero resonance with the opposition. Zero, because they said, well, it's your constitution, you're the one who rammed it through. So why should we play by rules that you yourselves wrote? That was a problem. That was a huge problem for Egypt, I think, in the spring and summer of 2013, when they had no accepted rules. Whether they should have been accepted or not, that's a fair question, but there were no accepted rules. And I worry about this constitution in a sense the same way, that what it represents is because it comes so much from the Egyptian state that it won't have that same kind of legitimacy. Any legitimacy that it gains will be something that it picks up only slowly over time if people like the way that it operates.
I think just in a quick clarification for that, I think a lot of people are waiting to see the turnout on this referendum. The last constitution, which passed by 64%, had a turnout of 31%, which means that 69% of the Egyptian people just didn't bother to vote. So, well, but it wasn't typical for Egypt. It had been going down gradually, but the first ones were, in the 70s. Now, this time, a similar low turnout will indicate similar dissatisfaction and similar lack of acceptance for this constitution. So I think everyone is waiting to see what's going to happen next January. And so.
Oh, this is just, my name is Danny Stoker. I'm with the Middle East Institute. But my question actually just has to do with voter participation in this upcoming referendum. Al-Masr al-Yum today reported that there are members in the Elections High Committee that are considering imposing a fine on people who will not vote. Do you think this would go, how this would go over in this upcoming referendum? How do you think this would go over in the upcoming referendum? Do you think it's something that's even realistic that could be enforced?
Good luck enforcing.
That's on the books. It's never been enforced, right?
There's always been a fine if you didn't go and pay it. And to the best of my knowledge, it's never been enforced. But there's always been a fine. So.
Manar Ghunaim from Middle East News Agency, Egypt. I totally agree with what you have said about the extensive power given to the president in the new constitution, you see. But don't you think that this is much related to the weakness of the political parties in Egypt? Because still Egypt suffers from very weak political parties, you see. Even the Freedom and Justice Party in the previous experience in the parliament, still it was a very weak party. It was just related to a group, you see. So I don't know, and if this is, are you measuring the new constitution according to the ideal Western norms and values without taking into consideration the Egyptian differences? I don't know.
I deliberately don't give an evaluation of whether this is a good or bad constitution. I'm not eligible to vote. I won't have to pay any fine. But what I would say is I'm just trying to figure out how it will operate. And that's the analysis that I try to give. How will this actually work within the context that actually exists in Egypt right now? Your other question about the weakness of political parties, I think, is a very, very important point, and it actually is related to the earlier question about the contrast between the 2012 and 2013 processes. To me, this is actually a fundamental crisis in Egyptian politics, and one of the major reasons why I think the revolution turned out the way that it did. When you got to the stage of normal politics, and normal politics being, some kind of electoral politics, including a degree of electoral politics, most Egyptian political forces simply were not ready. Egypt has one political party, that's the Freedom and Justice Party. And it has other parties that exist on paper. But even the Freedom and Justice Party, as you say, is kind of linked to an organization. And what that meant was that when it came time to sit down and have the various political forces bargain with each other, there was nobody who could really deliver anybody, and there was too much of a temptation, I think, to rely on very strong state actors, the military, the security apparatus, the judiciary. And that's where Egypt has wound up, in a sense, I think, where those political forces have the political force, the political parties within political society, within civil society, are simply too weak and too divided to sort of stand up and impose any kind of constitutional order on the Egyptian state.
Thank you. All right. We're going to have to wrap up because we are out of time. There's one is this a quick question, sir?
Sure.
Go ahead, please. This is our final question. Because
hi, Eric Spiak from the Project on Middle East Democracy. The original constitutional mandate originally called for parliamentary elections to follow the referendum and then presidential elections to follow that. But this new constitution draft has really opened the door for the interim president to decide which elections are going to take place first. Can you guys comment a little bit on the ramifications that could or could not have?
Can we just have Sahar do that? Because
I find it to be problematic mainly for political reasons, because if it's in the Constitution, it only applies one time. I mean, and you're thinking of a Constitution's longevity. I don't like seeing all these clauses that apply to this particular unique circumstance. But in terms of how it's going to play out politically, I interpret it as, okay, Adel Mansour is the interim president who's supported by the military, and my view is I suspect he can't make any major decisions, maybe some small minor decisions, but no major decisions without having the Minister of Defense approve it, who arguably may become the next president of Egypt. And so the question mark I have is, will interim President Mansour decide based on what's in the best interest of potential candidate Sisi? And as opposed to based on other non-political considerations, or at least non-partisan considerations. Is it better to have a parliament first as opposed to a president second, and how does that impact kind of the legitimacy of the next government? So I just find that there is a conflict of interest, at least an appearance of impropriety in terms of conflict of interest. And I don't know, Professor Brown, what do you think in terms of how that's actually going to play out, if that's a difference? Is that a distinction without a difference?
in 30 seconds.
We'll see. 5 seconds.
Brilliant. That was brilliant. Right, ladies and gentlemen, thank you so much for coming, and we hope we see you again soon. Go and vote.